Hello, everyone, and welcome to Design Denmark's webinar. When will Denmark start protecting its small designers? This is a little bit polemic, titled by Eric K. Clemons, a Professor Emeritus from the Wharton School of University of Pennsylvania, which we have with us today. And Eric is going to give a talk about how you value harm from the infringement of small designers' protected creations. And this is the reason why we're doing this webinar, is because of the upcoming trial in the Supreme Court, where Anne Black and Netto is clashing over her designs that Netto stole. We have Eric with us today, and he will give a talk about how you can estimate the damages and how you can actually start protecting our small designers. So I just think that we should take it away, Eric, if you will.
Thanks very much. I assume we're live and the microphone is on. What we're going to
Eric, you are muted.
No, it must be here. One moment.
We can hear Eric. It's fine.
We can hear.
Okay.
Yeah.
I didn't think I was muted. Good. Okay, let's get started.
Eric, we still can't hear you.
I'm sorry, Henrik. Am I on now?
I can hear you, Eric.
That's good. Hi, Charlotte.
Well, I'm going to start with the assumption that I'm allowed to speak now.
Yeah.
And what we're going to talk about in brief is the difference between theft of design and the destruction of reputation. The case is novel, but it's not complicated. The appellate court found that Netto had copied the look and feel of Anne Black's marketing material, which we call trade dress. And that's actually more important than copying any of Anne Black's protected designs. When you copy the trade dress, it makes it look like Anne Black is now a Netto designer, is now working for Netto. And if she's working for Netto, she's no longer an exclusive designer. This destroys the value of the brand. And once this is understood, the only interesting question remains, how do you value reputational harm? Okay, traditional theft of design is relatively simple. Imagine two designers, Intel and AMD, they both make chips. One company sells the other's design and sells copies as if the design were their own. The harm is based in an obvious way on the value of the unauthorized sales. The harm is limited only to the single design that was copied and only during the period of infringement, and the calculation of harm, the calculation of damages that need to be compensated, is the value of the lost sales, those sales that the stolen design didn't get to make. And that's a form of theft. In contrast, reputational infringement is a form of vandalism. If the retailer steals the design of a famous designer and sells cheap copies, not as if they were their own, not as if they were Netto's, but as if they were still Anne Black's, this destroys Anne Black's reputation as an exclusive elite designer. The harm is not limited simply to the products that were copied, but all products, and the harm lasts until the reputation is restored, long after the copies have stopped being sold. This is critically important to Denmark. Without high tech, California is a place with great coastal scenery, high rent, expensive labor, and agriculture. And the US defends its high-tech intellectual property, getting Secretary of Commerce, even Secretary of State involved when the copying is significant enough. Without design, Denmark is also a place with great coastal scenery, high rent, expensive labor, and agriculture. And Denmark does not appear to defend its small designers' IP with nearly the diligence that the United States protects its designers. Signaling is an interesting concept. Most creatures, not just humans, have a way of signaling status. Signaling has to be difficult to fake. So if I want to convince someone that I'm extremely well connected or I'm extremely wealthy, I drive an expensive car, I wear cufflinks. Cufflinks were invented because with a proper cufflink, it's impossible to dress yourself. So if you're wearing cufflinks, it's proof that you're wealthy enough to have staff that dresses you in the morning. This isn't just limited to humans. When Thompson gazelle are chased by lions, the gazelles stot. Stotting is a bizarre behavior where a gazelle will jump 10, 12 feet vertically into the air and come down motionless. And that's a way of advertising to a lion that I'm faster than the others. And if you chase me, you're going to end up hungry. Peacocks have enormous tails as a way of saying to a peahen, I can carry 40 inches of useless feathers around. I'm strong enough to do so. These are all ways of signaling superiority. Anne Black's designs were a way of signaling taste, judgment, and wealth. If something becomes easy to get, it loses its signaling value, and that destroys the value of a luxury brand. Reputational capital is a way of describing the value of a brand. If you destroy the signaling value of an elite designer's product, you destroy the designer's brand value. The harm is not based on what Netto did sell. Remember, in the case of Intel and AMD, harm is based almost entirely on the value of the stolen designs that were sold. Here, the harm is not based on what Netto did sell, 300,000 kroner, but on what Anne Black no longer can sell. It seems to be in the neighborhood of 60 million kroner. That's a huge difference. And one of the ways I view this is actually as vandalism. This isn't theft. This is vandalism. If a thief takes a crowbar, rips the door of a Mercedes open instead of breaking the window, rips the stereo out of the wooden dash and steals the stereo, the insurance company doesn't pay the $700 that the thief got. The insurance company pays the thousands of dollars it takes to repair the car. The harm in this case is not the 300,000 kroner that Netto sold. The harm in this case is the almost 60 million kroner that Anne Black can no longer sell. If you take a look at this very simple graphic, you have a trend line. You see the seller's sales going up quarter by quarter. And then you see an infringement. You see something that harms the value of the brand. If you're looking at traditional theft of intellectual property, AMD versus Intel, then the harm is that little yellow-brown zone. It's the sales that you didn't make because the other company made them. And eventually it goes away when they stop copying. If you take a look at reputational harm, that's that huge gray zone, and that just doesn't stop. The copying of the chips may stop, but the copying of the infringed design, the copy of the harm that came from the infringement of the design continues for as long as the reputation is damaged. And as long as the designer appears to be working for Netto, and nothing has undone that, Anne Black ceases to look like an elite designer, and the damage continues. There's a form of analysis that, economic analysis of harm that's always done in litigation. It's called but-for analysis. What would Anne Black's sales have been but for the infringement, in the absence of the infringement? To do this properly, we have to rule out other sources of harm. So for instance, if every ceramics retailer in Denmark had lost sales, then the harm is not caused by Netto's actions. If everyone selling ceramics had supply chain problems, again, this wouldn't have been a Netto problem. If Ann Black's management team had changed, you need to make sure that there's nothing else that happened. And in the case of Ann Black's company, her designs were copied by Netto, her sales collapsed, and nothing else happened to destroy her business. So first thing we established that the harm occurred after Netto's actions, that nothing else in Ann's operations caused the harm, and then we need an explanation. And the explanation is loss of brand value as a result of loss of signaling value. Okay, now we know logically that the harm was caused by Netto. But how do we demonstrate exactly what the lost sales were? And to do that, we take a look at what sales were before infringement. We predict what they would have been in the absence of infringement. We take a look at the difference between the two lines for as long as the reputational damage goes unrepaired. And the difference between those two lines, the difference between what Ann would have sold and what Ann did sell, is the way you calculate damages. I like to take what an economist or a physicist would call steady state examples. So I ignore the very early period in which Ann's business was growing very quickly, but in which expenses were very high, since they really, they bias the estimates either in favor of low profit or in favor of rapid growth. What I do is I follow the most conservative procedures I can, which is to do what business interruption insurance would have done, which is to take a look at sales at the end, final period sales. And that ignores the possibility of future growth. That's as conservative as I can be. And similarly, I take a look at how low sales have gotten, but I don't assume that they'll go any lower after that. So again, I'm doing this as conservatively as I can. I take a look at what Ann's sales were at the time of the infringement. I take a look at how low they got over the next 4, 5, 6, 7 years, and I use that to calculate loss. So there are two parts to the loss. One part is the difference between expected sales after the infringement and actual sales up to the present. So there will be harm that will continue because Ann's reputation has not been restored. But I take a look at the sales from the time of infringement to the present, and I compare that with the sales just before the infringement. That's part one. That's the losses that have already happened. Part two, which is legitimate, it would be done in business interruption insurance, is to take a look at the losses that have not occurred yet. And that's from the present until the reputation, the restoration of the company's reputation. Now I compare the expected sales based on history to expected sales based on the history after infringement. That sounds really complicated. So let's make that simple. Take a look at the graph you see in front of you. There's a jagged line. It shows that sales started off low, they got higher, they oscillate as is normal in a small business. And I have that jagged line. If you see on top, there's a dotted line, and that dotted line is the projection forward from the last period before Netto's infringement. So that line tells me what I would have expected Ann Black's sales to have been if nothing had happened. That's conservative because, as you can see, there is a slow trend of growth, but I'm assuming no future growth. I just plot out what Ann did sell in the last period for which I have data. And I project that out until her reputation is restored. Part one, if you take a look at the pink region shown in part one, that's got a jagged line also. And that jagged line at the bottom is what Anne actually did sell. Doesn't require sophisticated analysis to take a look at the trend line before the infringement, the sales before the infringement, and the sales after infringement to see that sales collapsed. So part one of the loss is the sales Anne has made to date compared to the sales Anne could have expected in the absence of infringement. And that's the pink zone called loss part one. And that's actually quite dramatic. It's in no way related to the very limited sales that Netto actually made, roughly 300,000 kroner in copied sales. How can this be so dramatic? How can Anne have lost tens of millions of kroner if Netto only earned hundreds of thousands of kroner? That's because Netto's action wasn't traditional copying. It wasn't copying of two chip designers, where Intel or AMD sell the designs as if they were their own. In this case, Netto is selling Anne's designs as if they were Anne's designs, not as if they were Netto's designs. That's the whole point of copying trade dress, the look and feel of her marketing. And this very small sale for Netto destroyed Anne's reputation. At a minimum, I would argue that Anne Black is entitled to compensation based on the loss shown in part one. However, losses didn't stop today. Anne has thousands of flower pots in her warehouse that she cannot sell, not because they're any less attractive than they were 7 years ago, but because her company is less attractive than it was 7 years ago. Reputational harm in large publicly traded corporations is actually based on taking a look at the market value of the company, taking a look at the share price. And if the share price has gone down 30%, the loss is indeed 30% of the company's market value. You can't do that with a small company that has no publicly traded shares, but you can still take a look at the loss in trade volume. What I did is, again, conservative. I'm assuming that Anne would have had no future growth, but I'm also assuming that Anne's value the sales would not go down below what they are now. That's as conservative as I know how to be. I'm saying there would be no future growth. The sales would not decrease further. And the difference between her sales in the last period before the infringement and her sales last period now, that difference projected out until the harm is repaired, that's her future loss, which is loss part two. I'm assuming there may be some questions. I was told to leave a few minutes for questions. So we're basically almost done. In conclusion, this case is important to design as an industry in Denmark. People don't come to Denmark because of its mink farms. People don't come to Denmark because it produces spectacular butter. People come to Denmark because of wonderful design, and my hotel advertises Danish modern. If we destroy Danish design, then suddenly we do Norwegian modern or Finnish modern, and Denmark becomes an agricultural exporter. Harm here is based on the destruction of the designer's reputation. Again, it's more like vandalism than it is like theft. Harm is not based on what Netto sold, but on what Anne Black did not sell. Harm is not limited to the products copied, but applies to all of the designer's products. Harm is not limited to the period of the copying, but persists until it's rectified. Harm is not based in any way on the value of a flower pot design. In fact, the appellate's court said that two of the designs really didn't merit protection as designs. The appellate court decided that the real infringement was destroying Anne's reputation, destroying the brand's importance to the consumers, and therefore destroying Anne's value going forward. I'm happy to take any questions now if there are any. Henrik, back to you.
Thank you very much, Eric, for that wonderful and very clear presentation about what really is at stake here. I have a question to begin with, and that is, how do you estimate when the brand has been repaired again?
I guess one way to do that is just to see when the sales continue, when the sales resume at their previous level. What I had suggested to the attorneys was that part of the settlement, which would have dramatically reduced the cost to Netto, was a public acknowledgement that Anne had never authorized the copying. Netto has never done that. It looks like an apology. Just to repeat something I put in the press release, Netto destroyed the value of Anne's brand as a way of getting people into the store. There's something called high-low marketing or loss leaders, where a store might sell a popular brand like Tide below cost and lose money on that. Netto, instead of selling Tide below cost, sold Anne Black copies as if they were their own. They're not. So if Netto apologized and publicly acknowledged that this was not done with Anne's authorization, that would be a huge step towards restoration. But right now, there doesn't seem to be a recovery in sales yet, and there's certainly been no public acknowledgement of Netto's role in the harm.
No, to the contrary, I think they at one point they said that it was actually marketing for the designers that they. But I have a question from the chat here, and it's first of all, they're thanking you for a great presentation. But then they're asking, how do small companies and individual designers best protect their IP and brand from damage and theft in the first place?
Now, there are norms of behavior that I have some Arne Jacobsen chairs. I bought them from Arne Jacobsen's seller. They're real. There are norms that say when you can and when you cannot copy. And when those norms are no longer observed, then the courts have to get involved. What I'm hoping is that the courts will understand the importance of this case. I didn't come to Denmark because I thought Anne Black was a company of global significance. I came to Denmark because I thought Danish design was an industry of global significance. And the court has the opportunity Monday to declare that copying a designer's trade dress, masquerading as a designer, is a tort, is a wrongful harm, and needs to be compensated. And the mechanism is the loss of sales by the designer. As soon as the court establishes that as the norm, designers don't have to do anything. If somebody copies the trademark of a designer, in law, this is called a rebuttable presumption. And right now, Anne has to prove reputational harm. If the courts establish a precedent, then the copier has to prove the absence of harm. A rebuttable presumption says, if you copy a design, the assumption is that the designer is harmed. You may be able to prove there was no harm, but the designer does not have to prove harm. Once the court establishes that presumption and the presumption of a rebuttable presumption, then the problem solves itself.
It seems to me that what Anne Black is doing and her lawyers are doing here in the Supreme Court is that they try to push the envelope just a little bit, but not too much. I think they're asking for 3 million. And that is an estimate that is quite far off from what your estimate of damage actually is. So let's say that they get this 2 to 3 million in compensation. What does that leave? Not Anne Black, but Danish design, for if the Supreme Court gives that kind of verdict?
No better off than the small designers are now. In the United States, it's possible to ask for a small amount of money. And if the court or the jury believes that the harm is much greater, what you can be awarded is actually much greater than you asked for. In the case of the Ford Pinto, where Ford decided it was okay if the car exploded, and they made a calculation of what it would cost to fix the car and decided it was cheaper just to pay damages for the people who were killed in the car, the courts awarded far more money than was requested. I don't know that Denmark ever does that, but at a minimum, the court could say actual harm was 30 million loss at wholesale, 60 million loss at retail. Damages awarded are 3 million only because that's what was requested. But if the court were to say the actual harm was 30 million kroner wholesale, 60 million kroner retail, we were awarding only 3 million, at least that establishes the precedent. I've discussed this with Anne Black as a company and with their attorneys, and I think they're being too conservative. I think they're being dangerously conservative. I think the court did not take this case because they thought one designer was that interesting, or because they thought 300,000 kroner in inappropriate sales was that interesting. They wanted to stop using the destruction of a designer as a way of getting people into the store for 1 week during Easter. In other words, they wanted to stop this as a practice. And Anne's attorneys are not giving them the court the opportunity to do that. The court can still award Anne Black what she asked for, but notice that the actual harm is much greater. And that's what will be awarded to the next plaintiff. And at least the precedent is established.
Yeah, we can at least hope for that, because now I'm quoting the chat again. They are talking about this other case with Kasper Wirtz and Christian Bitz, who was just decided recently, where they were awarded about 7 million in compensation. But again, 7 million, and the claim was 39 million. So actually not a good win for the designer there either.
The problem with that case, and again, the reason I presented this really pedantic, the graphs, and I actually did statistical analysis, and I set up spreadsheets. I made it much more complicated. But the reason, and Stina Teilman-Locke and I have published a paper on how this should actually be calculated. The reason we did that is even in this most recent case, this most recent ceramics case, the court had no idea how to value the lost sales. And they did something traditional, which they took a look at the incremental sales of the infringer, and they awarded the designer whose design was copied a percentage of the infringing company's sales. That's not the way it should be done. It should be done the way I laid it out. Take a look at what their sales would have been, take a look at what their sales are, and subtract out the difference. That's how I would have done it, but that's not how the courts have done it in either case. It's not how it's done in business interruption insurance. It's not how it's done in the other cases where I've been involved. You don't take a look at what they sold. You take a look at harm. You take a look at what they didn't sell.
Yes, and we can only hope that the Supreme Court will make this statement, although, well, maybe it's just me that's pessimistic, but let's keep on hoping at least and see where we are at in a couple of weeks' time when they've given their verdict. Eric K. Clemons, thank you for your wonderful presentation and lots of positive feedback from the chat. So thank you very much, and thank you for coming to Denmark to fight the good fight.
Thank you for the opportunity to speak to you.